Welcome to our most recent Friday afternoon webinar. Thank you all for being here. As many of you know, Legal Services has been putting on webinars every Friday during this pandemic about COVID-19. If you've missed any of them, we do have a YouTube channel where you can watch the ones that we've done previously. They're about Families First and some food stamps and other public benefits. So that information is available, as well as you could always reach out to me. I can put you in the right direction. Just real fast, the webinar is put on by Legal Services. Legal Services is the free legal service to low-income people across the state of Alabama. We have 8 offices and 56, 57 attorneys, but we always can use more help, which is one of the things Taz is going to talk about in a minute. But a few things about this webinar, because I get the same questions. You know, we have probably about 200, maybe a little bit more people attending this week. We get the same questions every week, so I start off always explaining what the basic rules are, because people, you know, will keep asking the same questions. The first big one is if you attended, if you signed up, if you registered, if you gave us your bar number, and if you used the email link that came out, you will get credit. We will print a list off with your name on it. The computer knows who's attending. You do have to stay for at least most of the presentation. It'll also know if you open up and then just leave. But I don't think anyone's going to do that, because this is a really popular topic. A lot of people have been asking for this. We're very excited Allison's here to talk to us from the department. So if you want credit, you will get credit automatically as long as you gave us your bar number when you signed in. Second thing, we start these a little early so people can get their audio and visual issues fixed. We have had, in the last couple of weeks, since the internet's been stressed with everyone working from home, a couple of people say the audio goes out for 20, 30 seconds, but it usually comes back. So if it just goes out and everything else is working, just hold on for a second. It'll probably come back on. It happens to about 10% of the people attending at least once during the presentation. But the material is available in the menu on the side. I tell everyone this every time. The material is always there to download right now. And someone, at least 4 or 5 people, will ask me afterwards, and that's fine too. I'll give it to you afterwards. But it's available right now if you want to download it and have it available. It's there. Last thing before we get going, if you have questions, use the question box. And that's questions for me about audio or visual or things that are going on in the webinar, but also more and more importantly, for Allison. Allison won't be able to see your questions. You won't be able to ask your questions as she's going. So you will have to type them out, and I will ask them I'll wait till there's a pause and ask them. You can go ahead and send them as soon as you think of them, and I'll just ask them at the appropriate time. With that being said, we do have a lot to get to. So first thing I'm going to do, Allison, I'll let you introduce yourself. We're usually on the opposite sides of things, legal services and departments, although we really admire the job they've been doing recently, and well, the job you always do, but more so recently. I'll let Allison introduce herself. But first I wanted to introduce our board member and the head of the Advocacy Committee for Legal Service Alabama, Taz Shepard, who has a special message about volunteering and pro bono. And with that, I wish you all luck, and I will be available for questions as this goes along.
Okay, thanks, Mike. Thank you. That's great. This is a very important topic, and I'm really pleased to see so many of our lawyer friends here in Alabama are signing on to learn more about it. We've got a great speaker, so we will certainly benefit by this hour. As Michael said, I'm on the board of Legal Services Alabama, and many of you know me as chair of the solo and small firm section of the state bar with almost 1,000 members across the state. We've promoted this webinar on our listserv, so I hope many of you are connected with our section. And by the way, those of you who know me know that I don't typically have a beard. My son Ty and I practice together here in Huntsville, and we have a contest to see who can grow the best shelter-in-place beard in about 3 weeks. Don't tell him I think he's winning, but we'll see. So this will probably be gone, pretty soon, but for now it's fun. Anyway, I wanted to tell you that not only is this event good for you for your practice, it gives us an opportunity to consider everything that LSA does for low-income people in our area, and also the similar organizations or coordinate organizations of volunteer lawyers. I was president of the volunteer lawyer program in Huntsville a couple of years ago, and still a volunteer, and I can tell you how important their role is, even if you're not going to the office, even if you are at home sheltering in place because of your health. There are things you can do, you can volunteer for, such as counseling over the phone. There may be a person who has overwhelmed by legal issues like a difficult landlord, or not sure how to pay on a credit card, or having received something in the mail that's alarmed them in a legal sense. You can help right now, or you can contact the volunteer lawyer program and say, when this lifts and I can go back to the office, then I will take a couple of cases, or I will again counsel people. There's so many ways you can be a servant leader in your community. I really encourage you to reach out to the State Bar volunteer program with Linda Lunn. Covers most of the state. There are individual programs in Mobile, Montgomery, Birmingham, and Huntsville that concentrate on those areas. And between them, if you call the wrong one, they'll send you to the right one. And it's so wonderful if you can get engaged. The other thing I want to mention real quick for all of you that are interested, last year we had incredibly well-attended probate practice CLEs around the state, 6 hours and lunch for $30. Obviously, we can't do that right now having live events. We did have the one in Huntsville this year for district practice, and we're working right now with Mobile and Montgomery and Birmingham to have them online just like this, so that you can get your 6 hours, including an ethics hour. So look for the notices to go out very soon, like within the next 2 weeks, if you want to participate in those and learn things like landlord-tenant law, guardian ad litem, and other things. And LSA will be participating with us on that. But enough of that. Once again, please find ways to volunteer in your community, especially while you have time right now. And let's give a big welcome to our excellent speaker and pay good attention to the things she's going to tell us today. Thank you, Allison.
Thank you, Taz. My name is Allison Hatfield, like I was introduced, and I am Assistant General Counsel for the Alabama Department of Labor. I've been with ADOL for about the last 6.5 years or so, and I'm happy to be here today to talk to everybody about what's been going on with unemployment. I know that everyone will probably have a lot of questions. I will do my best to answer those questions, but first, just wanted to go ahead and get started. The format that I'll be kind of working from today will be just to do a brief overview of regular unemployment benefits, because that system's still in place, very, very much as it existed previously. And then we'll kind of drill down a little bit more into the new federal programs that everybody has heard about through the CARES Act. So Michael, if you would please go ahead and advance to the next slide. And that is kind of maybe a little awkward thing that's going to be happening today. I pre-created a PowerPoint for today, but I don't have access to it. Michael's going to be advancing the slides for me, so I'll be telling him when I need him to do that. So first of all, we've had some questions about how much is available as a weekly benefit amount. I'll be using WBA for that here and there. So that amount is $275. It used to be $265. It changed very recently, just at the start of this year, 2020. So understandably, there's a little bit of confusion about that. I've tried to include legal sites to as much of my information as possible, just because I know I find that helpful if I'm attending a CLE. But at any rate, the maximum amount of benefits that a person could claim for regular UC benefits will be $275. The duration that benefit is available is currently 14 weeks. In Alabama, that number has also recently changed. It used to be 26 weeks. I can understand there might be some frustration about this given the current circumstances, which obviously were not in play when the legislative decision was made to alter the number of weeks from 26 to 14. But I will give everyone a little bit of a spoiler alert. We'll get to this later, but it's really not going to make a difference with the federal extensions and the way all of that's going to work. A person who would otherwise be eligible for regular UC will have the same amount of potential weeks that could be collected regardless of what this 14-week period is. It's not exactly 14 weeks forever, as you can see in the slide, as the state's average unemployment rate raises by every 0.5%, an additional week would theoretically be added to that entitlement with a maximum of 20 weeks. Given the current circumstances, you might think that that would be, being put into place immediately, but the way the law is written, that statewide average is taken based on the third quarter of the year. Obviously, we're not there yet, but again, that decision will be made based on data from the third quarter, and even without that, even if we don't increase to 20 weeks, everybody's going to get the same number of weeks possible with all of this together, and we'll get into more of that a little bit. And I also added there are 5 additional weeks in addition to whether it's 14 or 20 that are available if a person is engaged in a state-approved training program. I listed a few of those, but that's where we are. That's the amount and the number of weeks available under regular UC. All right, Michael, if we could go ahead and move to the next slide. All right, going back. Okay, there we go. All right, so under regular UC, everybody has what's called a waiting week. So the first week for which they claim benefits, you just skip it. That's the way it normally works. You also have some pretty basic eligibility requirements. The first, making a claim for benefits might seem a little obvious, but this comes up more often than you'd think. A person actually has to make their weekly certifications in order to receive benefits for that week. It doesn't matter if you initially qualify, you don't automatically get the benefits. You have to certify each week that you meet these eligibility requirements, which include being able and available for work, that you're searching for work, that you're totally or partially employed during the week at issue, and that you have sufficient wages in your base period in order to qualify you for benefits. Michael, let's move on to the next slide.
And I will say, Don Harrison will also be available if you need any sort of comments in the meantime.
Okay, great. Don, if Don is another assistant general counsel with ADOL, I asked him to listen in today, and so if I leave something out, he'll be able to jump in and help us out with this. Okay, so even if you meet your basic eligibility requirements for UC, you still have to not be disqualified for those benefits. And some of the ways that you can be disqualified don't mean that you've done anything wrong or bad. It just means, in the first example that I provided, that you maybe are an independent contractor or you're self-employed. Additionally, if you voluntarily quit your job without what we call good cause connected with your work, that is also a disqualification. We're going to be talking about good cause a good bit today. It's a fairly stringent standard. There has to be an element of involuntariness there. So you might even have a really good reason. That reason might be you need to take care of your parents, or your spouse has moved away and you need to move to another state. That's considered a good personal reason for leaving your job, but it's not considered a good work-related reason for quitting your job. Examples of that that Alabama courts have found in the past have been, for example, egregious sex harassment that you as the employee, you've tried to rectify, you've tried to get help in dealing with, and if your employer just allows it to continue, for example, that is a scenario that might be considered good cause for voluntarily leaving your job. But otherwise, you're expected to, if you have a job, to keep it. Of course, likewise, if you are discharged for misconduct, whether it's more egregious forms of misconduct or what we call simple misconduct, then you'll either be totally or partially disqualified for benefits. All right, let's move on. Next slide. All right, so what I've just discussed is sort of a basic framework, a very, very basic framework for how a person would qualify for benefits under the regular UC program. Prior to the CARES Act, before that ever happened, but as concerns were rising about COVID-19, we got some guidance from the US DOL about how to maybe apply some flexibility in our administration of the unemployment program here in Alabama and, of course, throughout the country. This guidance was provided via a document that I'm going to be calling a UPL. You'll see that there in the first sentence of my slide, it's UIPL. That stands for Unemployment Insurance Program Letter. And these are documents provided to all the statewide workforce agencies, the agencies that are implementing state unemployment benefit programs. Those are instructions that we get from US DOL because much of the implementation of our programs are dictated by federal law. So these are our marching orders, if you will. So on March 12th, we received a UPL from the US DOL. That's UPL 10-20 that instructed or didn't so much instruct, just advised of flexibility that states would have in administering their programs. States were not permitted via this UPL to waive the able and available criteria, but were told that they could exercise flexibility as to how claimants might satisfy that requirement. For example, if a business lays off a number of employees and it's intended to be a temporary layoff, and this is the way things were before. This is just an example that the UPL gave us to apply to other similar situations. So a business lays off a number of employees. It's intended to be on a temporary basis. During the period that those employees are laid off, they are permitted to apply for benefits. They are not required necessarily to go through the same stringent work search requirements as you might be otherwise because they are considered able and available for the particular job that they were laid off from. So in order to satisfy that able and available / work search requirement, the employee just needs to take reasonable steps to preserve that job. In other words, to come back when they're recalled. And they're not necessarily required to, show that they tried to get a different job. They just have to do what they need to do to keep the job that they should be called back to. That UPL suggested that states waive that waiting week that I discussed earlier, and Alabama has done that. And it also suggested that states consider non-charging employers directly affected by COVID-19, and Alabama has also done that. Let's move forward, Mike. Next slide. UPL 1020 also provided a couple of examples, I guess, intending to give states, again, a little bit more guidance on how to apply these more flexible standards. One of those is if an individual is quarantined by a medical professional or under a government order, like a shelter-in-place order, and either the employer has advised the employee to return at the end of that quarantine or at the end of that shelter-in-place order, or even if the employer has not provided clear guidance to the employee. In this scenario, states were told that they could treat that similarly to the last example I discussed, where they're considered able and available for the job that they had. And while they're on quarantine or while they're sheltering in place, they're not necessarily required to go out and beat the pavement looking for work, and for obvious reasons. The second example is a little bit more confusing. We've got a lot of different variables. The first is if an individual is quarantined by a medical professional or government direction, or if the employee leaves the employer due to a reasonable risk of exposure, we will call that a self-quarantine, or to care for a family member. So these first three scenarios, and the employee either intends not to return, or the employer tells the employee that they can't return. We've got a lot of different variables going on here, but basically what the UPL says is that states can, again, be flexible. Under normal circumstances, let's use the one about leaving to care for a family member. When I discussed good cause as to a voluntary quit before, this might be a really good personal reason to leave work to care for a family member affected by COVID-19, but ordinarily that would not be considered good cause because it wasn't connected with work. Under this example, it sounds as though states are being advised that they could treat that reason as good cause, especially if the employee or the employee's family member, for example, was in a susceptible group, an older person, maybe they were immunocompromised. I believe these sorts of factors will be considered by states in trying to figure out whether or not, that type of separation constitutes good cause. All right, let's move forward to the next slide. So the last UPL I discussed was number 1020 that was issued in on March 12th. Shortly thereafter, a little over a week, we had the passage of the Families First Act. I'm sure everybody is pretty familiar with that. Probably associate it most with the emergency paid leave provisions and the expansion of the FMLA as it related to COVID-related reasons. But Families First also contained provisions that impact the administration of, again, we're just talking about regular UC benefits. We haven't gotten into the CARES Act yet. So this UPL provided states with a little bit more flexibility even than what was provided for in number 1020. And real quick, before I go any further, I do have a hyperlink at the end of the presentation where everybody can go and find these UPLs. But also, if you're just looking for them right now, I mean, you can Google it. You can just UPL 1020, it'll come right up. They're really helpful, and I'll be referring to them frequently throughout this presentation. And I just think going forward, they're really useful. Everybody should read them. All right, so I'm sorry, did we have somebody coming in? Okay.
I don't think so.
Okay, good deal. All right, so UPL 1320 was the program letter that all of the state agencies received in response to the information in the Families First Act that pertains to unemployment compensation. Again, just as in UPL 1020, we were advised that we could waive the waiting week as well as charging employers, which again, Alabama has gone ahead and done. UPL 1320 also allowed states to either temporarily modify or even suspend the work search requirement for individuals unable to search for work due to COVID-19. And this, I'm including language from the UPL. This isn't my interpretation of it. The rationale given was specifically to encourage social distancing as recommended by whether it were federal, state, or local guidelines. Which I think is kind of important, and that's probably going to vary from time to time depending on who is telling us to do what as far as social distancing is concerned. But this waiver or modification allowance is not just because jobs aren't available, it's also to encourage social distancing. This UPL also allowed states to have a little bit more flexibility with good cause and how that good cause requirement is interpreted. So just as we were talking about earlier, if an individual needs to leave his or her job for what you would think of as personal reasons, not work-related reasons, one thing we could consider is if that individual was immunocompromised, for example, or in a highly susceptible group. So all of these factors address purely how ADOL and other state agencies implement their regular UC programs. All right, moving on to the next slide. Let's go into the CARES Act provisions. I know that's probably what most everybody's interested in. This first slide about CARES Act, we're just going to kind of go over some broad strokes. All three of these programs that are bulleted in this slide are 100% federally funded. So this is all federal money. As a state agency, we're just funneling it, more or less. So let's first talk about pandemic unemployment assistance. This is the acronym is PUA. That's how I'll be referring to it from now on. This is up to 39 weeks of benefits essentially for individuals who wouldn't normally qualify for the UC program. gig economy workers, independent contractors, people who are self-employed, even people who don't have sufficient wages in their base period to otherwise qualify for benefits. It's really broad and it's really different. It's unprecedented for people who don't meet these basic qualifications to be otherwise eligible for what's essentially unemployment benefits, but it is specifically to provide this sort of safety net, if you will, for these groups of people. These benefits are also available for people who have exhausted regular UC benefits. So you might initially at the beginning of this qualify for regular benefits under the state program. If you exhaust the number of weeks available to you under that program, then you could theoretically file for PUA. This program is effective beginning February 2nd, 2020, and goes to the end of the year. And the way the weekly benefit amount is calculated, it will be exactly the way it would be calculated under regular UC. The only really obvious difference is, especially if with the example of a person who doesn't have sufficient wages in their base period, that amount will default to it's also announced in a UPL, the DUA, the Disaster Unemployment Assistance Minimum, which is currently $113. So PUA will be between $113 and the max of $275. Next is the Federal Pandemic Unemployment Compensation Package. That's the $600 payment that everybody keeps talking about. I think it's probably the most widely publicized aspect of this package. It is an add-on to any benefit, whether it's regular UC or PUA, or the next benefit in the slide that we're going to talk about, which is essentially an extension of regular benefits. This benefit will be available between March 29th, 2020. That's the date that Alabama entered into the agreement with USDOL to implement all these programs. And it will be available until the end of July. So it has a much shorter duration. And finally, Pandemic Emergency Unemployment Compensation. As I just mentioned, this is simply an extension of regular UC benefits. So if you qualify for regular UC and you exhaust your 14 weeks, then you would be eligible for PEUC. Your weekly benefit amount would be the same as it previously was under regular UC. And you would, in addition to that, get your, I'm going to call it FPUC, that's the $600 payment, until the end of July, of course. Pandemic Emergency Unemployment Compensation that I just mentioned will also be available to the end of the year, and its initial starting date is also March 29th. Practically, if you think it through, payments of PEUC probably won't be made for a while, just because it's going to take people a while to run through their regular UC entitlement before you get to that point. So, order of payment with all of these different programs, it can be very kind of confusing to think about. So I've tried to lay it out in the simplest way I've known how. A person who is potentially eligible for regular UC would need to go ahead and apply for those benefits. If those 14 weeks are exhausted, then that individual would file for and be eligible for PEUC. That's the extension for regular benefits. Next, if that person, and I'm sorry, I realize I just didn't mention the number of weeks available under PEUC. PEUC provides an additional 13 weeks beyond the 14 that are allowed under regular UC. So if a person exhausts their additional 13 weeks, it's possible that Alabama will do what is called triggering on extended benefits. I've included a little bit of information, but not much in the slide. And I apologize. Michael, would you actually go ahead and advance to the next slide? I realize I didn't ask you to do that. I apologize. All right.
And I will note that we have, I think about 10 questions already. I'm still waiting because I think you will get into some of the questions, but there's a goodly number of questions, some of them with multiple parts.
Yeah, I'm not surprised. Okay. All right, well, we'll get through and hopefully we'll be able to answer some of those questions just with the information provided, but if not, I've tried to leave some time for questions for sure. But anyway, back to triggering on EB. If anybody's interested, that statute that pertains to that is Alabama Code section 25-4-75. I'm not going to really get into it because it's not currently triggered on, and to my knowledge, there's no expectation that it will be triggered on, but that is a potential additional benefit that could happen and that would follow PEUC. In the event we do not trigger on EB and an individual exhausts their additional 13 weeks of PEUC, at that point, an individual could theoretically apply for PUA, which we discussed at first. So I've kind of given a little bit of an equation. I'm not exactly the most arithmetically talented person, but let's just work it out. So if you have 14 weeks of regular benefits and then 13 weeks of PEUC, and then you can be eligible for PUA after that. And one thing I have to mention about PUA is a person who's exhausted their regular benefits and PEUC. Once they're then available for PUA, that total 39 number of weeks that are available under PUA has to be reduced by the number of regular benefits and EB benefits, if it's triggered on, that were received. So no matter how you fill in this equation, you come to the same number of weeks every time, and that is 52. So if Alabama increased its number of available weeks under regular UC to 20, this would work out the same way every time, same with EB. Practically, the likelihood of a person receiving that full 52-week benefit seems pretty unlikely, just because you'd have to have started on regular UC really early in the year. Because again, all of these extension programs expire at the end of the year, other than FPUC, which of course expires in July. But I thought that this might be reassuring a little bit to people, because the 14 weeks that are available for regular UC in Alabama really are extended a great deal further than that as a result of these programs. All right, let's move on to the next slide. Wanted to talk a little bit in more detail about FPUC, the $600 payment that everybody's heard so much about. And real quick before I do that, the last little bit of discussion that we had about order of payment, more information can be found out about that in UPL 14-20. That's where I got pretty much all of my information for this entire presentation. So feel free to find that and read it. Like I said, these UPLs are really, really instructive and helpful, and they're available to everybody. They're publicly available. All right, FPUC. If you receive at least $1 of any available benefit, whether it's regular UC or PUA or PEUC, I've included a few more, EB, as well as the trade readjustment assistant benefits, DUA, that's disaster unemployment assistance. That's not been declared yet, but if it is, any of these benefits, if you get $1 of those, you're going to get your $600 of FPUC. It's just automatically applied. It is considered taxable income. Child support will be deducted from it, just like regular UC. Claimants who are eligible for the underlying benefit, in other words, they get that automatic FPUC add-on. If they have a prior overpayment, that underlying benefit could theoretically be taken away via offset, but they would still be able to keep the FPUC. Now the FPUC could also be offset, but only up to 50%. So let me explain a little bit more. This is kind of an unusual concept, I think, if you're not familiar with it. If you've previously filed for regular benefits and something happens where ADOL makes a determination later on that you weren't actually entitled to those benefits, that's what's called an overpayment. This can happen as a result of fraud, but it can also happen in a lot of just really ordinary circumstances that have no bearing on any wrongdoing by the claimant. It could be a situation where an individual applies for benefits, they're granted, but their employer appeals that decision and wins. That's just a judgment call. So so if you have this overpayment, this amount of benefits that you've been paid already before any of this happened, and you've been told by ADOL that you have to repay it, and it's non-negotiable. Anyone who has an overpayment has to repay it. In that case, if you later become eligible for benefits, then ADOL, if you haven't paid back your overpayment, can offset whatever future benefits you're entitled to collect those payments, if, like I said, if you haven't paid them back already. So it's just kind of an interesting feature of how this works. If you qualify for an underlying benefit, whether it's regular benefits, PUA, we're still kind of working out. We're not sure exactly the extent to which those can be offset, but there probably will be at least up to 50% of PUA, and for sure only up to 50% for FPUC. So even if you had this awful situation where you had to have most of your benefits offset, and if nothing else, you'll still get $300 of FPUC. All right. Also, if you had any prior fraud penalties, they cannot be placed on FPUC. However, any FPUC fraudulently obtained, it will be prosecuted. We will treat that just like any other sort of fraud. The only difference really is that we have a shorter window in which we can try to collect that amount. Usually it's 6 years, but for FPUC, as well as all of these federal programs that are in the CARES Act, we only have a three-year window that we can try and collect those. All right, next slide. Okay, PEUC, it's just extension of regular benefits. You have to be an exhaustee of regular benefits. So that can either mean you've received all the available benefits allowable based on your wages, or you've exhausted your benefit year. The same able and available and actively seeking work requirements that are applicable to regular UC also apply to PEUC, of course, but with the flexibility that we've already discussed. And with PEUC, we were given not additional flexibility, but just instructed, like, don't forget, like, this isn't a normal time. Work search requirements will not be the same as they are, you know, when you're going through a plague. All right. Let's move on to the next slide. As I said, I think I said this, Alabama law is going to apply to PEUC more or less in the same way that it does to regular benefits. So if for some reason you were unable to establish eligibility for regular benefits, or if you do, but then you have a disqualification, then not only will you not be eligible for regular benefits, but you will not have any eligibility for PEUC. Kind of same as to fraud, we can offset up to 50%, have a 3-year window to recover overpayments. Next, let's go on to the next slide and talk about PUA. And then after we're done with PUA, we'll pretty much be ready for questions. I know a lot of people are going to be very interested in PUA because it's so different. It provides benefits to those who would otherwise not qualify for benefits, as well as to those who have expired their eligibility for regular benefits. To qualify, a person must self-certify that he or she has, and I've listed them all out, I'll go through them, any number of different COVID-19 related circumstances that would make them eligible for PUA. First 3 right here, if the individual, him or herself, has been diagnosed with COVID-19, or is experiencing symptoms and is seeking testing, seeking a diagnosis. If a member of the individual's household has been diagnosed with COVID-19, and then if the individual is providing care to a family or household member who has been diagnosed with COVID-19 who's not able to care for him or herself. Some of these, we're still expecting a lot of guidance and clarification from USDOL, because just in reading these, you know, like the second and the third, there's no requirement that a member of the individual's household who's been diagnosed with COVID-19 is able to take care of themselves or not in the second bullet, but in the third, that is required. It seems if, you know, if an individual in your household is diagnosed with COVID-19, presumably that's enough, you know, that you might have been exposed and you need to self-quarantine for a period of time as a result of that. So I realize that's a little unclear, and again, we are very much expecting additional guidance from USDOL on how to implement that. So let's move on to the next slide, and just remember that, you know, if you have to leave work because you or somebody in your household has been given a COVID-19 diagnosis, chances are you will have eligibility for PUA. All right, if an individual is the primary caregiver for a child, either under the age of 18 or over in the case of someone who can't care for him or herself, if that child's school or childcare facility is closed as a result of COVID-19 and the individual, kind of requires that childcare in order to be able to work, then they would be eligible for PUA. One thing to remember about this provision is that it really only applies up to the time that the school would have closed otherwise. So if you apply for PUA under this provision and your child's school would have closed on May 31st, let's just say, then that's kind of the end point at which this provision would be applicable to you. I'm sure we'll get into this in questions, but I kind of envisioned that this will be a little complicated, especially if you had already lined up, daycare during the summer for the child. Well, I think it would apply for that too. You just have to not claim it during weeks that the child would have been home anyway, that kind of thing. If an individual is unable to reach his or her workplace due to COVID-19, this could, due to a shelter-in-place order, for example, or if the individual has been advised to self-quarantine by a health professional because of, a reasonable concern of infection, this could apply to somebody who, has underlying conditions, somebody who's particularly susceptible to it, that could apply, as well as to those who are scheduled to commence employment, but that maybe that offer was rescinded due to the crisis, or they were unable to get to work due to a shelter-in-place order, for example. All right, next slide. Another qualifying provision is if a prior head of household contracted the illness and did not recover and passed away, if someone else in the household had to then become the breadwinner, this provision would apply. If an individual has to quit as a result of COVID-19, they would be able to apply for PUA. The example that I've given in this slide comes directly from UPL 16-20, which is the one that applies directly to PUA. I don't know how helpful this example is. It essentially states that if you, are diagnosed with the illness and you recover, but you are left as a result of that diagnosis with other medical conditions that make you unable to perform the essential functions of your job, with or without reasonable accommodation, that this might apply to you. That's certainly an example. It seems like a highly specific one. What I have gathered, and again, we are hoping for additional guidance from USDL on this provision and others, is we're still looking for some element of involuntariness. If, for example, an individual is immunocompromised and is working for an employer who exhibits some sort of callous disregard for the virus. Maybe the employee wants to wear a mask and gloves to work, and the employer says, no, you're not allowed to do that, and I want you to stand right here within 6 feet of somebody who's coughing and has a fever. Again, I'm getting pretty specific too, but those are the types of things I imagine that will be looked for, not just I don't think it's safe. Like, you got to show why you don't think it's safe, I would imagine. Of course, if the individual, if their place of work is closed due to COVID-19, that's obviously going to affect a lot of people. And finally, this catch-all provision, if someone is self-employed, even if they're seeking part-time employment, they don't have sufficient work history or wages, or otherwise would not qualify for regular benefits or EB, as long as they can show that and one of the prior criteria that we just discussed, then they would be eligible for PUA. This is going to raise a lot of questions too, and we can, talk about those in questions if you want to. But as we are reading it right now, this seems almost as long as you have some work history in the last year, if you would not otherwise be available for regular UC for almost any reason, then PUA may be available to you. All right, let's move on to the next slide. We won't get into too much here, just fraud and overpayments will be more or less treated the same way as disaster unemployment assistance. Criminal penalties will apply, overpayments must be repaid. Particularly as to this point, we're again awaiting additional guidance from USDOL. We're hoping we might even get it today. So anybody who wants to follow along, I've included the link. That's where I go to look for updated UPLs from USDOL. And I really encourage everybody, if you're interested, to keep abreast of those UPLs because they are a wealth of information. All right, next and last slide before we move into questions. These are just kind of the scary things that you have to remember. This is not, these benefits are here for a very specific reason, and you have to have a good work-related reason to quit your job. You can't quit your job for the purpose of obtaining these benefits. You can't turn down full-time pay or refuse to work when it's available, or quit without good work-related or COVID-19 related cause. So these are things that I would want to tell my client if I were in private practice advising someone who was looking to file for unemployment benefits. I know there's a lot of concern, about, oh, are these, are people going to make more money on unemployment than they would if they were otherwise employed? But these benefits are for a short duration. They're for a specific purpose and an unprecedented event. And so hopefully they will work, they will serve their purpose, and we will do our best to not only distribute the funds as quickly as possible, but also to enforce program integrity. And that is it.
Okay, well, we have enough questions certainly to fill your time. And I think I sent Don had asked me to send 10 or so of the first ones. I think he may have put them so they're not just all separate. Are you there, Don?
Yes, I'm here. Yes, and I do have the questions kind of organized. I just sent those to Allison. So Allison, check your
my phone, yeah. Okay.
Or your email. And
yeah.
Joey Ammons, General Counsel, and he's on here as well. If there's a way to unmute him. So it's 12:44. I want to jump right in these questions. Allison, I'm going to take some that I know offhand, or at least that I'm confident in, and I'll handle those, but jump in. Let me first say real quick, I've worked here 9 years for the department, and I just want to say I really appreciate what Legal Services does. We come across them a lot, and you all do very important work speaking to the legal services attorneys out there, and I've become more aware during my 9 years here as it goes, just how important that work is. So we appreciate y'all. I mean, sometimes we're adverse to you all on these cases, but we do appreciate what you do. Okay, so, and one more thing on these questions. I think up until maybe, a month and a half ago, if you ask me a question or Allison or Joey, we could generally give you an answer pretty quickly. We probably would know the answer. And then starting about a month and a half ago, I started getting these questions, and I'm like, I have no idea. Let me look into that. So some of these we can go ahead and answer, and some, we may not know the answer offhand. All right, but I'm gonna start with some of these questions. All right.
Are you taking the first one,
Don? Yeah, I'll take the first one unless you've got it ready.
Okay.
If a person was fired from their job, got another job 2 to 3 weeks later, got laid off from there 3 weeks later because of COVID-19, and was denied unemployment because of the prior employer firing them, can they still apply for unemployment and get the federal $600 per week? Okay, the short answer is yes. I would always encourage any potential claimant to apply regardless. So, I think the real question is, can they receive unemployment benefits? And the answer to me is yes, if they are disqualified from regular unemployment. That may be a scenario where the PUA benefits would apply. Allison, do you have anything else there?
No, just that I agree. I think what would probably happen is that individual would get an initial denial letter I know we have been, correct me if I'm wrong, mailing out PUA information effective this week. So I think PUA would be the benefit that would be available to the person in this scenario. And whatever they were able to receive for PUA, yes, would be augmented by the $600 weekly FPUC payment.
Okay. And anybody else still, well, I'm going to skip number 2 for now, Allison, and
Okay.
go to number 3. It starts this way. Have some entrepreneur clients that need to know, multi-part question. Okay. Part 1, can a self-employed person, e.g. a single member LLC, obtain the $600 a week CARES benefit or any Alabama benefit if they are still in business but having negative impact from COVID-19? I'll chime in first. Yes, if they're self-employed, that's where the PUA, or sometimes we call those PUA benefits, come from. If anybody was around working on unemployment back in the days of the Great Recession, we had something called DUA, Disaster Unemployment Assistance. That's what this PUA is based on. Normally, a single member LLC would not be entitled to unemployment in traditional unemployment benefits, but with this PUA passed by Congress, I believe it was March 27th, which was a Friday, they're entitled to it. Now, it says if they are still in business but having negative impact, that's going to come down to if they still have income, they might make too much to receive unemployment. That's going to be based on their weekly benefit amount. So the answer to this is, the standard lawyer answer of it depends. It says negative impact. If they're out of business, they don't have any income, that's where PUA would kick in. If they have some income, it's going to depend on how much. And if they make over the threshold, then they will not be able to receive unemployment. But they would be able to receive up to $275 regular benefits or $275 in benefits plus the $600 through the end of July. Allison, feel free to chime in.
No, I don't really have any changes. Just, if you are still bringing in income more than the maximum weekly benefit amount of $275, you might, as Don said, just be earning too much to qualify for PUA. But that would be your only bar to file for that benefit, as I understand it.
Yeah, part 2 is essentially the same thing. What if the same self-employed person had a small side part-time job and continues to receive W-2 income? Almost the same answer. We have this a lot. They have a side job, but they have a W-2 job. It depends on how much the W-2 income is per week. If it's above the weekly benefit amount and the weekly benefit amount maxes out at $275, then they are going to have too much income to be unemployed. If their income is way down and it's below their weekly benefit amount, they could be entitled to unemployment. Anything else on that, Allison?
No.
Okay. And then this next part cut off a little bit. Part 3, how does a self-employed person report income? Looks like there may be some cut off there, but yeah, self-employed, because they don't have a W-2, it's going to be different. We get into what we're calling self-certification or what the law calls self-certification. They're going to have to certify how much income they have, and we are going to, as I understand it, verify on their tax records that they indeed have income. Allison, anything else on that?
No.
Well, but I will jump in here and tell you that the questions are multiplying like gremlins, if you ever seen that movie. So the faster you can answer the questions, the more succinctly you can answer them, the better off you're going to be, because there'll be enough.
All right, we're gonna move quicker. What if an individual was already on unemployment prior to the pandemic and now cannot find employment? Is there a method to apply for an extension? Yeah, that's that 13-week extension Allison talked about. Keep making the claims, and that extension should apply. Number 7, will church and other non-traditional employees receive up to $275 plus $600 or just $600? That's actually a softball for us. Yes, church employees receive the PUA, the Pandemic Unemployment Assistance of $275, and through the end of July, essentially, they'll get the additional $600. After that, it will go down to the regular weekly benefit amount. It may not be $275; it'll be whatever their weekly benefit amount is. $275 would be the max,
Correct.
and it's in essence, $875 is the max through the end of July. What if a person has 2 self-employed jobs and loses only one job? Do they qualify for unemployment? Depends on how much income they have. If they have too much income, they will not be considered unemployed and will not be eligible. Number 9, as I understand, the DOL is allowing employers to file UC partials on an employee's behalf for 3 consecutive weeks. What happens after those 3 consecutive weeks? Should the employee start to file afterward? No, continue for the employer to make the claims in that process. Allison, anything else on that?
No, from what I understand, that 3-week limitation has been waived, so the employer can keep filing partials, or the employee could file themselves.
Okay.
Is that best to
Number
understand?
10. Number 10 is an individual. It says, so to summarize, an individual can qualify for 52 weeks of $275 plus $600 up till July 25th. No, that's not really accurate. From the end of March through, essentially their exact dates, you can get them from the PowerPoint, but essentially from the end of March through the end of July, that's the only time period where that additional $600 comes into play.
That's correct.
Yeah. If a person was fired from their job, no, we already did that, excuse me. What's the current status of training programs that satisfy the additional 5-week period? How many of those are operating now remotely or any operating in person? That's one, I don't have an answer for that. That's part of the brand new law that went into effect January 1st, and I don't have information on that. Allison, unless you have anything, I'm going to start skipping to the next ones.
I don't.
Oh,
Okay.
Allison, what would does a substitute teacher generally qualify?
I'm not sure. I think it depends on the way that the substitute teacher was paid. If it was somebody just, picking up jobs here and there, I think they would be considered a self-employed person and would file for PUA.
What are the mechanics for employers reporting that employees have been recalled from furlough?
Yeah, there's kind of a specific mechanism for that. I think, Don, isn't it the new hire reports that employers have to turn in on a quarterly basis?
Yes, that's true. With substitute teachers, I believe they should get it until the school year ends. And after the school year ends, if that was the only employment they had, then I think it would stop for the summer traditionally.
Probably so. But there's no expectation of income during that time. Yeah.
Right.
If an employee chooses to self-quarantine, what happens if the employer treats that as a voluntary quit?
Again, I think that's just going to depend, as we were discussing earlier with good cause. If the employer treats it as a voluntary quit, but the employee presents information that, there was a shelter in place order, for example, and they were in a susceptible group, and that the employer was not, maintaining appropriate social distancing and other hygienic concerns. I think it's just going to depend on the facts.
Yeah. That'll be fun.
And again, this falls right in with PUA. If they were advised by a health professional to do that, if they can show that, that's a PUA criteria.
Well, I'm going to ask some of these questions. I think that you answered them pretty clearly, but you can answer them quickly now. If a person makes more than $275, will they receive any benefit under the new CARES Act if they're still making more than $275?
My understanding is that they will not.
If a person has 2 jobs, loses one, but is still making enough at the other job, will they qualify for UC?
It just depends on what they're making with the other job. They would have to report wages for that job as well. And if they made more than the 275, then they would probably not be able to collect anything.
Oh, heck. I think you already answered. If it was already on UC prior to the pandemic and they still can't find employment, they're eligible for an extension.
Absolutely.
Oh, they're coming in so many. When can people start to receive benefits under CARES? Have they already started being paid, or is that coming out later?
Yes, FPAC has definitely already started going out. I think it was last week. And PUA is being administered now. I'm not sure if any PUA has actually been paid yet, but it is being processed. And I just want to say, I mean, I know this is probably really frustrating for people, but you know, to put it into context, the entire year of 2019, 110,000 people applied for benefit. In the last 3 months, 330,000 people have applied for benefits. So the system is strained, and we're getting to it as quickly as we possibly can. But this money is being paid now, especially FPAC. PUA is being processed now. We expect that to be paid very soon. And of course, PEUC will probably be paid later, but only because it will be triggered later, if that makes sense.
Sure. Well, and Joey Ammons noted that, yeah, we are paying PUA this week.
Right.
And he wanted to point out, as an answer to one of the other questions, that people have to be careful that if they refuse any reasonable offer of employment, there may be disqualification if one's available. Let's see, is the cap still going to be $875 for people if someone makes less than $275 but it's still partially working? Will the $600 be added to whatever they get? So if they get $150, will they get $750?
That's correct. Until the end of July. But as long as a person is able to qualify and be eligible for 1 week of benefits, again, whether it's regular UC, PUA, or PEUC, as long as FPUC is still in play till the end of July, then yes, that is an automatic addition.
Well, people are asking some pretty fact-specific questions, which obviously Allison is just giving her best opinion, but are not any sort of legal. Someone asked, what about realtors? Many of them got paid in March, but there's no closings till July or August. Are they going to be eligible?
That's a really good question. So a realtor typically would not be eligible for regular UC. There's a specific code section that's applicable to people who maintain those sorts of licenses and operate as self-employed as realtors do. That said, as I mentioned with PUA, it's looking like as long as you've been working, PUA doesn't apply to somebody who's never worked a day in their life. But if you're working, just as a self-employed person, as a realtor would be, our understanding is that they would be eligible for PUA. But again, we're expecting more guidance, but that's the way we're reading it right now.
Sure. How can an employer respond if they believe that the person was terminated, or if the person resigned voluntarily before March 14th and is now claiming benefits? Is that fraud?
I'm going to have to ask you to read that to me one more time.
Sorry. The employer is saying that the person just voluntarily quit before March 14th and it doesn't appear to be COVID related, and is now claiming benefits as a COVID separation. Should they report that as fraud?
So that's not really how it works. What will happen is if a person voluntarily quit before March 14th, their employer would receive a request for information from ADOL, and they'd be asked questions like, what was the nature of the separation, and a box to check is a voluntary quit. And that's really all they need to say. And the department will investigate whether there was good cause related to that separation. I mean, the employer can opine, but they don't really report fraud, quote unquote.
Let me say this, as I understand it, a separation related to COVID or a furlough related to COVID will not affect the employer's experience rating. And on fraud, one thing that happens a lot with fraud, you may see our press releases where we announce the convictions of lots and lots of people for unemployment fraud. What happens is maybe we pay unemployment to a claimant, and then lo and behold, we do a cross check with our payroll systems, and we find that in fact they were receiving income during that time. Well, that's clear fraud, potentially clear fraud, and that's how we generally catch the fraud through that cross check system. I won't dwell on that anymore, but
For sure.
Well,
yeah.
We're a little bit over time, trying to still get the ones that came in beforehand. I think that the answer to many, there's a bunch of questions. What if there's a disagreement about the separation, or the person self-quarantines and the employer thinks that they're fine? I assume those are all going to have to be worked out, like those are going to have to be adjudicated somehow, right?
That's right. Just like regular UC, and Michael, you and I mean, we've worked together and apart on these sorts of issues, but this will be, this is going to really work, as I understand it, exactly like regular UC, in that, you know, if there's a disagreement between the employee and the employer as to the validity of the separation, the employee will make a claim, ADOL will make a decision, both parties will have the same appeal rights, and we'll duke it out, figure it out.
Yeah. I'm sorry, sir. The one who said I came a little too late. Can you repeat all that? I don't think we can do that. The one question I think, though, and then we'll probably be done because there's probably too many to answer. If someone uses leave, like if they have stored up leave at their employer and they're continuing to use that during this time, can they apply for unemployment?
No.
No.
The only possible exception to this is this is the example, and it's from a UPL. I think it's from UPL 1620 if anybody wants to look for it. But if a person is sort of underemployed, in other words, they haven't been furloughed, but their hours have been cut drastically, and or the employer has given them the opportunity to use some stored up paid leave to, you know, kind of offset the economic impact of not working full time. If a person is accepting, you know, some paid leave, but that they fall underneath that threshold of $275, it's possible, but they absolutely have to report that paid leave as, you know, wages essentially. And, you know, if the wages or paid leave in this instance are over $275, they're not going to qualify.
And I guess
the short answer to that question is under most circumstances, if you're utilizing paid leave, these benefits will not be available under most circumstances.
And is all income, including retirement, considered income for the purpose of UC? So if someone was receiving a pension and then they become unemployed, but their pension's obviously going to put them over, does that income disqualify them?
That
I had this.
Go ahead, Don.
Yeah, I had this question this morning, pretty much this exact question. As I understand it, a pension, it depends on if the payer of the pension is a base period employer. So it's kind of a technical legal answer. If it's a pension from somewhere you worked 10 years ago, my understanding is that would not count. But if it's somewhere you worked in a year and a half ago, roughly, then that's going to be a base period employer paying you a pension, and it's going to kick you out if your income is over the threshold. You're not going to be able to receive it.
And I do have one more question, which I'm going to ask because it's my former boss asking it, Larry Gardella. He's asking if someone was told to call within 4 days to resolve some issue, but they're not getting through right now. Is the department working with those people and giving them additional time if they can't get through? But you may not know.
I may not know that. I don't know if Joey Ammons is still listening in. That might be a question he may know the answer to. I would think so, but I don't know that I'm qualified to give a definitive answer to that question.
Well, and I will read off Joey's comments and then thank you guys, especially Allison. So Joey noted that the Department of Labor has been clear that quitting a job solely to collect benefits is fraud. We are not aware of any requirement to exhaust annual or sick leave before applying for UC. Must be, I'm not sure what that was a comment to. Joey really could have signed. Let's see, pension must be one that is contributed 100% by the employer. I guess that if it's contributed 100% by the employer, then it wouldn't be held against them. I'm not sure.
Real quick, Michael, if it's okay, I just got a text from Joey and he did want me to clarify that we are working with people who, if they've called and, instructed to call back within a time frame and they were unable to because of how overloaded our phones are right now. Yes, we are working with people on those deadlines.
Yeah, which I can confirm. I know that Joey was working with one of us not too long ago. So anyway, thank you so much, Allison, for this. It was great. We've had the same problem a couple of times now where the questions keep coming and they're still coming, but they'll just have to keep wondering. So thank you, Allison. Thank you, Don, for stepping in. We really appreciate it. And keep doing the great work you've been doing. We do appreciate it, even if we don't always show it.
Likewise. Thank you.
Thank you.